And today we are not just having this conversation alone. Our live audience joining us online will also have the opportunity to ask questions directly to our guests. Joining me today is a highly respected legal expert, the Chairperson, International Federation of Women Lawyers, FIDA Nigeria, Abuja branch. Please welcome Chioma Onyenucheya-Uko, FMTI. It's a pleasure to have you on the show, Barrister Chioma.
Thank you. It's my pleasure to be here.
Okay, so let's start from the foundation, because many people are working into marriage with assumptions instead of knowledge. Let's break it down simply. In Nigerian law, what really happens to property acquired during marriage? Who owns what?
Okay. Well, generally speaking, while it is believed that marriage is a union of two people coming together, I mean, oftentimes, because there are instances where it's more than two people, but I mean, the average will be two people coming together to form a unit, to become one. While that is the general notion of marriage, you know, that notion of oneness is not quite in a comprehensive sense. And that's to say that when it comes to ownership, when it comes to owning assets, owning things, they largely remain individuals, you know, except where there is a deliberateness in their merging their assets, except there is an understanding between, you know, the parties as to how those, you know, their assets will be held, whether it is in their joint names, whether it's each of them is owning their own things for themselves. All of those things will depend on the agreement between the parties and then the manner the marriage has been conducted, you know. So except where maybe there are issues and then the court comes in to adjudicate on the basis of equity, on the basis of fairness. Generally speaking, the parties in the marriage remain individuals and they hold assets or own properties or own anything in their individual names, except where they choose to jointly own those things.
So I'm asking, does marriage automatically give a spouse equal rights to property, or is that just a misconception?
I'm answering frankly. If I'm just to answer a straight to the point, yes or no, it is a misconception. My apologies.
Okay, so
it is.
All right, so love doesn't.
Yes, marriage
Love
alone
doesn't automatically translate to legal ownership here.
Yes. What it simply, you know, it kind of creates a legal situation, like a platform of sorts, where the parties can then, you know, maybe directly or indirectly own things together. Not that it is automatic. No, it's not automatic. It's not automatic.
Okay.
Yes.
All right. So how important are documents and whose names appears on them when it comes to ownership?
So the law doesn't deal with morality or emotions, you know, sentiments, all of those things. The law doesn't deal with that. What the law deals with is facts, hard, cold facts. Yes, sometimes it infers what ought to be, what should be, you know, in a progressive manner. Sometimes the law does do that. But generally speaking, the law deals with facts. And because the law deals with facts, documents are critical, they are vital, they are very decisive. Documents can determine what happens to you know, how a person's fate is decided. So it's important whose name is on a document. It's important, you know, where there are maybe a shareholding structure that all those are well defined. But where it is between two people, where the couple own it as a joint holding, that is properly reflected. Where it is either of them owning it individually, that person's name is clearly stated. whether it be a gift, even for purposes of a gift. Yes, it can be inferred, maybe by virtue of usage and the circumstances of the person coming into, holding that property. But even where it is a gift, the ideal thing, the proper thing will be that that gift is bequeathed in the name of the person whom it is intended for. So generally speaking, it is critical, it is important, it is vital that names of who owns what in a marriage are clearly stated in the document, the title document of that asset or that property, whatever it is.
Okay, that's interesting. A lot of people really don't know this. So what is the legal difference between property bought before marriage and during marriage? What's the different legal difference between them?
Okay, so when a person owns a property before marriage, that property is their personal property. It is theirs. It is theirs to own for always. Do you understand? Except for where maybe the parties decide to, willingly convert it to a joint asset. But otherwise, if a woman has bought properties before she became married when she was still single, those properties will not count as marital property, same as the man. So a person can continue to own the things they owned before their marriage, and the other person will not enjoy any automatic stakes in those things. But that said, where a property has been acquired after the marriage, it's a bit of a different ballgame. Remember that I had said earlier that marriage does not mean that what either person owns becomes automatic joint asset between both parties, right?
Yeah.
But I also made the point that in some situations the court may consider equitable interest in apportioning stakes, claims to that property, though it is owned by one person. But the difference now is that if it is an asset the person owned way before the marriage, just before the marriage, it will not even feature as one of the things the other person can enjoy any kind of equitable interest in. But if it is a property, it is an asset that is acquired during the pendency of the marriage, the subsistence of the marriage, then it's a bit, there are situations where the court will then look at certain other contributory or incidental matters to determine if the other party has some stakes or should enjoy some rights in that asset. And that will include where, for example, the other party shows that they made significant contributions to that union, which would have which ordinarily secures some economic rights for them, even in what the other party was acquiring during a marriage. And I use a very easy example. You will find in the course of my practice as a family lawyer, there are situations where you find a woman who maybe her role in the family has been to take care of buying food, providing feeding for the family, while the man has been the one maybe doing the heavy lifting, including building the family a home. In fact, I had a case of a client who was a teacher, and because the children of that marriage were attending the school where the woman teaches, the school was deducting the children's school fees from her salary. So which meant that she was the one paying for the children's school fees. She was the one providing for, the feeding of the family, while the husband was building the home that the family moved into. And her argument, which was valid, is that though the man was the one who built that house, though she did not financially contribute directly to the building of that house, but that she made the building of that house possible for the man because she contributed in other means by paying the school fees of the children, and providing feeding for the family within that duration. And all of those should count as stakes for her, as equity in that house that was built. So those are the situations where property acquired during a marriage can count as something that is owned by both parties, even if the name of both parties are not expressly stated on the title documents.
Well, so what we are saying is this: what people believe about marriage and property and what the law actually says are not always the same. And that's where the problem begins. They are not the same. All right, that's where the problem begins. So at this point, let's go for a short break. We'll be back shortly.
From Nigeria to the world, is the real conversation with housing diva. Real issues, real insights, real solutions. From the housing space to everyday life conversations. No filter, just truth. Is the real conversation with housing diva.
All right, welcome back to The Real Conversation. I've been speaking with Barrister Chioma Onyenucheya. Let's begin this conversation. Let's talk about the reality many people try to avoid: conflict. In divorce situations, what really determines who gets what, especially when one partner didn't financially contribute?
There are a number of things that will determine who gets what, some of which I've alluded to in the last response I gave. But for clarity, some of those things will include, whose name is on the document, for example, the title document of what is in contest, financial contributions between both parties towards the acquisition of that which is in contest. There are other non-financial contributions, which could include maybe caregiving role that was performed by one, or other support role that was performed by one, that helped the other acquire that asset. So I'll give an example. There are situations where you have a housewife, a woman who doesn't have any regular job, she's not doing any business, and usually, better still in circumstances where that decision was reached on account of a persuasion from the husband, because there have been, I've seen women who maybe had a business or they had a career, and their husband said to them, sorry, I think our children deserve or would need better attention than we can give them if both of us were to sustain a career or sustain a business. So I'd rather one of us, be a full-time stay-at-home parent, at least for these formative years until the children find their footing. And usually it is that, the woman is the one expected to make those sacrifices. The woman is the one who is expected to nurture and stay home. So in those kind of situations, if the woman stays home and forgoes earning income just to build the family, to nurture the children, to care for them, including cooking for the man, sometimes washing his clothing, and just generally caregiving for the family. In that situation, though she does not contribute financially to the properties acquired in that marriage, during a divorce, the court will consider her contributions to the union and then decide what will be an equitable formula to apply in sharing the matrimonial assets, as it were. So that's one of the things that those are the things that can determine who gets what. And another thing too may just be in situations where custody has been awarded to one of the parties, and the custody is awarded, maybe the one who has the emotional connection with the children, the one who does the caregiving for the children, is the one who doesn't own any title to an asset. The court can determine, on account of the fact that that is the one in custody of the children and the one who will be taking care of the children going forward. The court can also decide to apportion, reasonable assets to them from the asset of the marriage. So those are the things that can determine who gets what and all. There is no hard and fast rule to it. It depends on the peculiarities of each case. The circumstances of each case advises the court in how to exercise its discretion. But these are usually the framework on which the court makes those considerations.
All right, let's look at it from this angle. Let's just look at it from a woman's perspective, especially a woman. Can someone lose everything even after years of supporting a partner indirectly?
Sadly, the answer is yes. Sadly, but that's true. There are situations where a woman may lose everything. And I mean, I wouldn't want to say it's because she's been reckless, because recklessness, is relative. Sometimes just not knowing is what construes recklessness, and one may not, you cannot expect one to know what they haven't had the opportunity of being exposed to. So there are situations where a woman may lose everything. Then again, everything is also relative. I'm talking about the things that truly matter, the things that have some economic weight, the things that would have assuaged that person's hurt, after a union breaks. So a woman can lose everything. And this may again be determined by the circumstance of that case. Some of the things I had mentioned earlier are some of the parameters the court will consider in granting rights to a matrimonial property or sharing property between the parties during a divorce. Some of those things may also, on the flip side, be some of the reasons why a woman may lose everything. So if a woman has been in a union, and though she has substantially contributed, even financially, to the acquisition of the properties that the couple acquired independence during that marriage, the fact that some of those or most of those contributions were made without a trail, before we went cashless, there were many cases where women would have contributed money, and those monies were brought in cash, raw cash, without any trail, without any bank trail to show that XYZ transfer was made by A to B, And yes, her truth is that she did contribute, but there is no evidence. And I had spoken to us earlier about the importance of facts, evidence in court proceedings. So that kind of woman may actually lose any claims just on account of not having the right records to substantiate their claims of having contributed to the acquisition of that property. Then again, sometimes maybe where there is no child in the union, or where the custody of that child is not granted to the woman, or even where the woman has been shown to have also acquired her own assets, and it doesn't look like those assets were intended for joint ownership between the parties. Those are some of the situations where she may lose. I use the word everything, carefully here. Those are some of the situations where she may lose everything. So truly, a woman may lose everything despite her contributions, depending on the circumstances, and then, the facts adduced before the court.
That's a hard truth to hear. All right. What are the biggest mistakes couples make when it comes to money and property in marriage?
My dear, some of the biggest mistakes I see is that people treat money as if it's an emotional subject. It's not at all. Finance, money, there's nothing emotional about that conversation. So it must be treated with the seriousness that it deserves. It is a factual conversation. It is a legal subject. It is not something that should be allowed to rest on the whims and caprices of one party. There are people who will be most generous when they're happy, when they're impressed, when they love you, when they're enamored. and all of those. Now, when people can be indulgent, yes, but those same people who can indulge when they are happy, when they are excited, can also be the ones who will oppress, who will withhold favors and withhold provision when they are not so happy. So bearing in mind that these things can rest on, it can be precarious, it can flip one way or the other. It should therefore be a conversation that is had commonsensically. It must be discussed and probably documented. You know, it shouldn't be left to chance. It shouldn't be left to assumptions. It shouldn't be left to, okay, it is the man that provides, or a woman submits to her. No, 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 no. If you leave it to those things, you're leaving it to the emotional disposition of the party. And if you do that, because emotions are fickle, emotions can fluctuate, emotions are not something you can rely on, it then becomes a dicey thing for anybody to leave it to that. And then again, I also think that it is a grave mistake for parties to leave all assets in one person's name. And here again is where something about the blind trust I spoke about also plays out. Okay, because I trust my husband and he's the head of the family, and we operate in a patriarchal society, and it is commonly expected that a woman who submits to her husband should trust him and just feel secure in him, blah, blah, blah. Any of those kind of things should not be a reason why we're acquiring anything and we purport to have become one, yet that thing will be in one person's name. If the both of us are one, then we should merge our identities, Abby. We should become a clear unit. And being a clear unit does not mean that one person is subsumed into the other. No, it means that a merger happens. So that thing should be in our both names as a joint unit. So holding assets, putting assets in the name of one person is very dangerous. And this is not out of distrust for that person, because sometimes that person may be a very sincere, committed, trustworthy, reliable person in the union. But that person may suffer certain exposures. That means that things the both of you own, other people can now enjoy what do I call it now? Claims to those things, believing that they are privately owned by them. But if those things are held by the both of you, it then means that any third party who wants to make a claim knows that they are not claiming just against that individual, but claiming against the both of you. And if they have no claims against you, they cannot extend their claims to your stake in that joint property. And it also means that, God forbid, if life happens as it sometimes does, maybe even an extreme situation such as death, what the two of you own. Yes, I know that there is the place of inheritance. Yes, I know that there is the place where one can bequeath a thing either by a will or even by trust. But we're talking about primary ownership, where that thing is yours in as a matter of course, in your direct rights. The fact that both of you own it in your joint name means that they don't need to bequeath it to you. You already own it. Particularly, you already own your portion of it or your stake of it. So those are some of the things I think are mistakes, and people make them in relationships. And I think another one that I need to point out, maybe even earlier than the rest of those ones, is the fact that in marriages, or as people are planning to enter a marriage, the exuberance, the eagerness, the seriousness with which I see us plan the wedding ceremonies, what we're going to wear, the MCs and the photos and the ashwebis and the souvenirs. I do not see that seriousness in the conversations we have preparatory to the union itself. It's mostly about, seriousness over the ceremony and little depth to the real business that we'll be embarking on for the rest of our life, hopefully. So I think that money is one of those conversations that people should have early. to even determine compatibility or suitability of that partner for them. Because sometimes you may love someone, they are handsome, they are beautiful, they have the right appearances, but they don't have the right financial mindset. And if your financial dispositions are at variance, the likelihood that that union is going to hit the rocks is quite high. Because one of the things that feature the most when you look at the causes of marriage breakdown is financial matters. So it is a conversation that needs to be had early. And even as you have those conversations, there is nothing wrong with making the right kind of consultations. Consulting a professional, because sometimes family members or friends can, they can be sentimental, they can speak from places of emotions or bias. But when you consult a professional and you share certain discoveries, that professional will be better suited, will be in a better position to analyze the implications of those findings and advise you on options available to you and how you may navigate going forward. So I think we need to begin to treat our entry into marriage with more seriousness, because we've been treating it with so much levity. Yes, I see lavish efforts, but mostly around the ceremony and very little around the marriage itself. So those are some of the mistakes I think couples make.
Yeah, you've mentioned the mistake. A typical traditional man would tell you when you start talking about marriage, so this one is just after my money. So when it comes to things like that, some women want to be careful. They don't want to discuss money. But that is not how it should be, according to what you have said now.
You see, one of the reasons why that will even arise is because sometimes you find women, not sometimes, oftentimes, you find women who treat marriage like it were an escape from poverty, like it were some form of financial security measure, something with which they, secure themselves financially. And I don't think that is the right reason for a person to get into a marriage. I'm not saying that two people cannot agree on any reason. Two people can agree on any reason, because there are men who also just want it to be transactional like that, because they don't want anybody who comes to dictate anything to them. So some of them are comfortable to just have a woman who they know, see, I take care of you, but you're also just my trophy wife. Do you understand? So, but generally speaking, the reason why it is often a sensitive subject is because most women go into marriage not bringing much to the table. And I do not mean that the other things that a woman brings to the table are inconsequential. No, they are not, because many of them are things that sometimes border on life and death. But I mean that if a woman is coming into a marriage and she's also, a woman of worth, beyond just the things her femininity brings, beyond just the things that biology brings, do you understand? The chances that that man perceives her as a gold digger or as a person after their money, reduces. When people realize that these protections are mutual, they're symbiotic, that it not only protects one from the other, but can actually protect both of them, even from against the world, When it's treated from that mind view, that mindset, then those reservations tend to reduce or even just, disappear.
All right, very soon we'll be bringing in our live audience to, ask questions. Live audience, you can ask your questions or send them via the chat box in the Zoom platform. But before they do that, let me ask you this question. Have you seen real life cases where someone assumed ownership but legally had no claim? What lessons should we learn?
There are many situations where people assume ownership but have no claim. And it's not even exclusive to properties. And I'll just use a very easy example that is not quite property based. Someone is in a union and that union is not defined. They've lived together for years. no marriage in the real sense of a contract of a marriage has been entered. And then they feel that they have a claim to, a secured relationship with that person. That's an assumption that has no basis in law. So I'll take us back to what I had said earlier. The law relies on cold facts. Yes, sometimes it introduces equitable considerations for purposes of fairness, but on a general note, the law relies on what can be proven, things that can be verifiable on account of hard evidence. So that being the case, if you assume that because you have been the one taking care of your husband's aged mother, you've been the one having to sacrifice your career and settle for maybe a job or something that brings little to nothing into your pocket, or you believe that because you've been a dutiful wife, you've been faithful to your man, that it means that you're secured and that union is going to be, remain monogamous for all seasons. Those assumptions have no basis in law. They largely depend on the discretion of the judge. And because there are no compelling basis, it is not enough for one to just assume. If those assumptions are not tied to a legal claim, that ownership may just be a mirage. It won't yield anything. So there are situations where you find a woman who would have labored all her life supporting a man, particularly in the man's struggling years, and then the man comes into some real tangible value tomorrow and becomes affluent, and then the man decides that though this woman dropped out of school to take up menial jobs so that I can go to school, though she dropped out of school because she was pregnant and the both of us became a couple, though she sacrificed her dreams to support me to chase mine, now that I have achieved these dreams, she doesn't quite fit this new stature that I've attained. I need another person who would fit it. And then the man decides he needs to go and marry an upward mobile woman who he could, present in public. It will not be enough that you made all those sacrifices. If that marriage is not a statutory marriage, if it is marriage under native law and custom, that man can go ahead and marry whoever else he wants to marry. And even where it is a marriage under statute and the man is inclined, it may not also secure your claims in the event you opt out of that marriage, because you have a right to say, I don't want to be in a polygamous union. I would rather out. Going out does not also guarantee, it does not also secure that you are going out with, as much as you think that you deserve to get out of that union because of the sacrifices you've made, or the emotional and psychological and other support investments you've made in the union.
Wow. So at this point, let's bring in our live audience, because this conversation is not complete without you. So let's take our first question. If you have a question you want to ask Barrister Chioma, the floor is open. You're free to ask your question. Just raise up your hands and we'll unmute you, or you can send it as a message via the chat box. All right, I can see Memuna Bagudu. Yes. Let's get your question for Barrister Chioma.
Hello, good afternoon, Ma.
Yes, good afternoon.
So I have 3 questions to ask. The first will be, as a single lady who is not yet married, is it wise to ask about my partner's debts, his income, and assets upfront? Because sometimes when we try to have these conversations with this men, they tend to, look at it in a different way, just like the host earlier pointed out as to, or someone not perceiving you as a gold digger, or, you want to get all the records about his finances and all of that. But is it really safe in that, relationship window to ask these questions? And if you don't get tangible answers from this person, to handle it not to, give the person the wrong impression and get the right answers that you need? That's my first question, Ma. And then for my second question, there's this perception about women earning more than men. So for a single lady, if a woman earns more than her husband, are there any legal implications, or are there, any risks that she should be aware of? That's my second question. And then in the case of divorce, separation, and death, those who paid for, let's say, a property, for example, is it always determined under ownership during divorce? Main questions, ma'am.
All right, so starting from the first question. And I think the first and the second are a bit close-knitted, in the sense that they border on a woman's sense of security or sense of self-worth. So if a woman in trying to get into a lasting union needs to have certain conversations to determine the suitability of that person as a compatible partner or spouse, I do not know why we prevaricate over the conversations that are vital. So if it's going to hurt his ego, if it's going to make him perceive you as not quite the right kind of woman, that already should tell you that that's not the man for you. Because every man who is secure in his sense of esteem, who is exposed, who is enlightened, who is broad-minded, will not find anything wrong with you having those conversations. What it tells that man is that this is a woman who is likely to be prudent. This is a woman who is likely to be serious-minded. This is a woman who will be a great asset for me, even for my financial planning and my management. This is a woman who will groom the right kind of kids, raise our children with the right kind of financial mindset. So that man should already see that you're an asset. And that man should already see that you understand the seriousness of partnership, and you need to know what you're up against, or the things you have, both of you are going to have in your favor, that will aid you as you plan into that marriage. So it shouldn't be a thing that makes the man uncomfortable, particularly when that woman is also willing to submit to the same level of scrutiny. Are you going to be uncomfortable to also share with the man what your debt exposure is, what your average income per annum, or whatever periodic income what's it called now, estimates that he wants to know? If you're going to be willing to offer what you want to also extract from him, if that man is uncomfortable, if that man perceives you in a not so positive way, it's on him, it's not on you. It means you shouldn't be unequally yoked with that kind of person. It means both of you cannot sync in your thought process, in your outlook to life. So if that woman becomes uncomfortable and hesitant to proceed on that conversation because she does not want to offend, because she does not want to scare him away, because she does not want to lose him, it is a woman who is insecure. It is a woman who lacks self-confidence. It is a woman who is desperate to just land a man, to the extent that she wants to land anything, just any kind of human, so long as that person is of that gender. And I don't think that is a win. I don't think that's a prize anybody should go for. So that's it for your first question. And then I think it trickles also into the second question about the appropriateness, of a woman earning more than her husband. When it comes to a team doesn't check to see who is doing more, who is doing less. A team checks to see the willingness between the parties for teamwork. A team looks to see Hello?
We can hear you.
Okay, my apologies. The call was trying to interrupt. So I'm saying that a team looks to see that each party on that team, each member of the team is willing and ready to bring forward their best selves to the success, to the, for the good, to optimize the output of the team. So if I have more and I bring more, it is inconsequential. What is more important is that my readiness, my willingness to bring even the little that I have. So if all I have is maybe just my physical strength, for example, it counts for something. You're not going to judge me by the things I don't have. So in the same vein, if a woman is the one who earns more, maybe on account of her choice of career, her business niche, maybe her background, the advantage of some early advantage on account of, a financial structure that has been built by her parents or her forebears, maybe on account of the kind of course she read or the network that she enjoys, or even on account of where she has lived, her location, whatever it is that makes a woman earn more than the man, it shouldn't matter if that marriage, that union is predicated on the right principles. What that man will be seeing is a willing partner who will deploy whatever benefits she has for their mutual advantage. And it works vice versa. But particularly when that woman doesn't allow that financial advantage, rub off on her personality. For those of us who are Christians, we believe that there's nothing we have which we have not received, right? So it means we don't boast on just our assets, whether they be tangible or not. So if that is the case, it means that woman will remain humble, respectful, despite her attainments. And when I use the word humble and respectful here, I'm not using it in a subjugative sense where a woman, where people perceive that a woman should, dim her lights or reduce or shrink herself to give a man comfort. No, that's not what I'm talking about. I'm just saying that she's going to remain respectful, just as she would expect to get respect from her man. So it shouldn't matter at all if a woman earns more. It is of no moment. And then when it also comes to maybe asset sharing in a union, and then that woman is the one who earns more during the subsistence of a marriage, and God forbid that marriage goes south. The same way that a woman would expect to enjoy from the assets of the man, because men are typically the breadwinners, the ones who have the more tangible assets. That is the same way that man may be entitled to certain pronouncements from the court for his security, financial security. If that woman has exposed him to a standard of living that he ordinarily cannot sustain, and then he has also given, to support the woman's growth or the woman's continuation at that status, at that level, then it only makes sense too that if he has any financial claims, that the court will look at it equitably. Again, that word that I've mentioned before, equitably, fairly, what will be just. So if it will be just that the court makes an award to the man from the proceeds of the woman or from the assets of the woman, because the woman is the one who earns more, so be it. The important thing is that justice is served. The third question you asked is about sorry dear, can you remind me the third question? I know it's something about a divorce.
Hello, Memuna, are you there? Unmute her, please.
Yes, ma. Okay, for the third question, yeah, let me. Hello, ma, can you hear me?
Clearly.
Yes.
Okay, ma, for the third question, if a spouse dies without a will, what right does the surviving partner have? Because there's this a friend of mine who lost her husband 2 years ago, and there's a bit of an issue when it comes to his property, because apparently before his death, he did not leave a will.
No
And it's
problem. I'll
causing
answer
a lot
that.
of, yes.
Yes. So where a spouse dies intestate, that's what we call it in law, where he dies without making a will, a few things will depend on the kind of marriage the parties entered into. If it is a marriage under native law and custom, the prevailing culture, the prevailing tradition will apply. If it is a marriage under the statute, then it will be governed by the requisite estate laws or wills law of that the state, because it varies from state to state. But generally speaking, where a man dies intestate, it may not be automatic that everything he owns goes to his wife. The man will typically have successors that will, yes, primarily include his wife, but there'll be other people, including their children, and in some cases, other dependents like aged parents, siblings. There are men who are the breadwinner, benefactor, provider for an entire clan, for a village. If that kind of man dies without making a will, and maybe that man is married under native law and custom, in sharing the man's assets, they are going to share to even some of his siblings and to his parents and things like that. That is why it's important, again, like I said, financial matters or economic matters pertaining to property, to assets, to money, all of those kind of issues, they are not emotional subjects. They are not things you should, leave to lovemaking. No, you don't leave it to, I'm going to just massage his head and I know he'll be happy with me and he'll take care of me happily, and we live happily ever after. They don't work that way. There are things, there are real life situations that come up in seasons that are oftentimes less than affectionate, in situations that may sometimes even be hostile. So because of that reality, there are things you discuss from early on so that you can secure yourself ahead of a possible rainy day. So I don't know if that answered that question.
All right, so we have to prepare ourselves ahead of a possible raining day. Thank you to everyone who joined us live. Your questions show how important this conversation really is. You've really answered our question thoroughly. This conversation may sound heavy, but it is necessary because ignorance, they say, is expensive. But the good news is there are ways to protect yourselves. Let's talk solutions because knowledge leads to action. What practical steps should couples take to protect themselves financially in marriage?
Okay, so this will take me back to some of the things I had said earlier, but now in reverse order. So one of the things couples should do to secure themselves is to start with having the tough conversations. There's no avoiding it. You either have it in the good moments or have them in the bad moments. So it's best you have them in the good moments. Have them before the love grows cold. Have those conversations before a ring is put on it. And if a ring has already been put on it, have that conversation in the days when you can prepare his favorite food and two of you can lounge somewhere and you're able to get him in an agreeable mood to have the conversation. Those conversations are critical. The other thing will be, I think, honestly, I recommend parties realizing that though they are one, it does not extinguish your autonomy as a human being. The same way you have your phone, the same way he has his phone, you have your clothes, he has his clothes. That is the same way you can have other things. It doesn't, excuse me, it doesn't diminish the authenticity of the love the both of you share. It doesn't reduce or threaten the sanctity of your union. All it does is that it shows that each of you have respect and regard for each other's autonomy, for each other's well-being, and you're happy, you're ready to ensure that you are each protected at all times, you can own properties in your name. I have assets in my name. I have a few, jointly with my husband. But there are some that I bought in my singular name as Chioma Onyenucheya-Uko, and his name does not feature. When I apply for visas and I need to show a tie to Nigeria as part of justification for being deserving of getting that visa, one of the things I would usually include will be to say, I own this, I own that. And I won't be saying I own it if my name is not on it. So these things have far-reaching legal implications for women, and sometimes in situations you would not have ordinarily envisaged. So it is absolutely proper and well encouraged that a woman owns assets in her name, and in those situations where both of you combine resources to own it, that the document, the title to that asset should reflect your joint names. And then in those situations where a woman supports her man towards an acquisition, especially maybe in the building of a matrimonial home, my darlings, I encourage you to keep clear records. I hope your marriages thrive. I hope that you just continue to enjoy your union. It blossoms and blossoms for always until death do you part in a ripe old age. But there have been many situations where we see that that is not quite the narrative. And nobody plans for that. Nobody hopes or wishes for it for themselves. So if you find yourself in a situation where things go sour and that marriage has to be determined by a court, one of the things that will readily come to your aid is a trail that the court can see, a hard proof that is verifiable, an evidence that you've documented, I transferred XYZ, particularly in this age where we are now going cashless, where you do banking apps and all of those things. Can you have clear narrations to the monies that you send? I send money and then I write soft loan to my husband because he has said, Becky, can you raise me a quick 1M there? I need to make up for XYZ. Me, I write it too. I clearly write, I say loan. I transfer to him. That's how I write. He knows. And then when he's also sending it back to me, he also writes refund of loan or repayment of loan. He writes it. Then the one that is a gift, maybe on his birthday, and I just want to spoil him with one little, even if it is 60,000, 10,000 that I have, I want to give us. I also write there, birthday gift. Do you understand? So normalize stating the narration. Thank you. Narrations on your transactions. Normalize documenting your transactions, your contributions, those investments that you make to support. Even when you're paying for the children's hospital bills, when you're buying clothing for them, normalize documenting it. Because some of the things we hear is where the man now presents himself as the one who has been providing everything and the woman does nothing except just eat his money. And you find that some of those women earn income. So you'll now be wondering, so if you earn all this money and there's nothing to show that you contribute to the home, it then suggests that all your earnings have been going into your private estate, into just taking care of yourself alone. And it weakens your stakes in getting from what the man has built, So you should be able to show that just as he has been paying school fees, you have been the one doing the weekly or bi-weekly shopping for groceries for the family. You've been the one spending your money, taking care of the medicals of your both aged parents. You've been the one paying domestic staff in your house and doing all those. They may seem like little things. That we've done computations where even something as seemingly little as the payment of DSTV subscriptions monthly could amass to something substantial over the years.
All right, so let's leave the floor open now for Chioma. You raised your hand while I was asking the question. So the floor is open now for you to ask your question. That will be our final question for the day.
Thank you so much. This has been a very enlightening discussion. Barrister Chioma, I thank you for this conversation that you have brought to bear. My question has to do with, you know, women who are in service. You know, most times you have the men having their next of kins as their wives, but most often the women have either their siblings or probably their children as next of kins. How do you address that? Because oftentimes it becomes an issue. The man sees himself aligning with the immediate family, that is himself, the wife, and the children, while the woman aligns herself with her siblings in the case of death. How do you address that? Thank you.
Okay, thank you very much, Ma. And that's a very real life based question, because I've encountered things like that. And truly, you see, I think what happens is that we seem to misconstrue the purport of a next of kin provision. You know, that thing about a next of kin. So a next of kin is ordinarily not one's successor. The fact that you have named your daughter, your son, your younger brother, your younger sister, you know, anybody close to you as your next of kin, and I'm speaking to women now, does not mean that in an eventuality that person inherits you. That's not what it means. It's not the automatic implication. A next of kin is essentially, using maybe a loose language that anybody can understand, a very simple language. A next of kin is that person that can be contacted in an eventuality. So, because most women operate from a place of sentiments and emotions, that is why they would appoint their young children as their next of kin. When indeed that young child you have appointed as your next of kin cannot take decisive steps in an eventuality. So if that person is the one that is called upon to provide information, to even for one to break news to them, you know, to ask their instructions on something that is your due in the office, will they be able to make that informed decision? They won't. They will still rely on a third party. So a next of kin, she's not something we should be handling from just that emotional point of, I think my next of kin is the person who is going to inherit me when I'm no longer here. That's not what a next of kin is. And then appointing one person a next of kin does not also automatically mean that you cannot, you know, in making a will, that you cannot also devise your assets to several other people. You can. It's possible that your daughter is your next of kin, or your son is your next of kin, or your younger brother or younger sister, as the case may be. Though those people are your next of kin, in devising your assets under a will, it is possible that you will even devise some of those assets to persons who are not your blood relations. It is possible that some of it is donated to a charity cause, you know. It's possible that you now bequeath some things to even people who have served you in your home as caregivers over the years, as a way of giving back to them or to their own children. So I think we need to not continue to misconstrue who a next of kin is. I am aware that there are establishments where a next of kin is almost elevated to the point of meaning an intended successor. But no, that's not what it means. If someone contests it in law, that person will have a right footing, because it does not automatically mean that person succeeds you or inherits you. So what it also means is that while we may appoint anybody as our next of kin, we must be careful to also ensure that we take necessary steps for our assets to devolve to the right people we want it to devolve to when, you know, life happens and we have to transit to the other sphere.
All right, thank you so very much, Barrister Chioma Onyenucheya. This has been an eye-opening conversation. And if there is one thing to take away, it is love is emotional, but property is legal. Thank you so very much, Barrister, for your time on the program. And to my viewers, thank you for being a part of the Real Conversation. Keep the conversation going, because real talks leads to real solutions. Don't forget to subscribe to the YouTube channel, Flora Anne TV. See you again, same time next week. Bye for now. This is a Real Conversation. Don't forget.
From Nigeria to the world, it's the Real Conversation with Housing Diva. Real issues, real insights, real solutions. From the housing space to everyday life conversations. No filter, just truth. It's the Real Conversation with Housing Diva.